Welcome to our Mark Chambers seminar on rates mitigation and charitable relief case law discussion following recent decisions of the court, including, of course, the Supreme Court in Rossendale. We're delighted to see so many people on this call, and we hope that you'll find the discussions that we're going to have informative. But we're going to adopt a slightly different format from usual. There aren't slideshows at the moment. For this presentation, we're going to have discussions. First of all, Luke Wilcox and I will be discussing the Rossendale judgment and its implications for example, macro. And then Jenny Wigley and Admas Habteslasie will be discussing charitable relief in the light of the Nuffield judgment and how it has implications for other cases in the rate mitigation sphere. So. Some housekeeping points, first of all, if I may. First of all, your microphones are on or automatically on mute, so you don't need to adjust anything for that. You should be able to see a question and answer tab at the bottom of your screen. Please feel free to ask questions through that tab, and we'll do our best to answer it as we go. This webinar is being recorded, and we'll be sending out the recording in due course. If you lose connection at any point, then you can just jump back straight in by going back to the email with the connection on it. Now, I'll do some quick introductions. I'm Dave Forsdick, QC. I've done quite a lot of rates mitigation cases over the years on both sides, currently waiting for a decision as to whether we're going to get permission to appeal on the Ludgate House case to the Supreme Court. Jenny, many of you will know, has been involved in the Public Health England case, which Rossendale is of some significance for, obviously, and was also involved in macro and advises local authorities and ratepayers on these sorts of issues. Luke Wilcox, many of you will know, who's active in this area and is with me in the Ludgate House case, and also has been involved in several of the rate mitigation schemes, including Public Health England at the outset. And Admas similarly has a practice that covers local government and rates, as well as his other areas of expertise. So what we're going to do is we're going to start with a discussion between Luke and I on the implications of the Rossendale judgment. So Luke, if you could come on the screen, hopefully I can see you.
Good morning.
Good morning. Thank you. Thank you very much for coming on. Now, obviously, to some people, the Rossendale judgment drives a coach and horses through established principles of rating. To others, it's a classic exposition by the Supreme Court of the purposive approach to interpretation. Parliament cannot possibly have intended to grant rates exemptions in this situation, and therefore the Supreme Court has used a purposive approach to construction. In the next few minutes, we're going to look at those two different perspectives and also see how far one can push the Rossendale judgment in other situations, like the macro type case or the PHE type case. So first of all, Luke, could you just explain in headline terms, please, this rate mitigation scheme in the Rossendale case?
Yes, of course, and thanks very much, Dave, and good morning to everyone. I'll pin my colours firmly to the mast at the outset. I'm in the coach and horses camp on the effects of Rossendale and Hurstwood, and we'll get on to why later on. In terms of what the scheme involved, there were two types of scheme, but for these purposes, they had a great deal in common. The scheme involved the creation of a single purpose vehicle. So a company which classically has one director and one shareholder, with the share being worth £1. The owner, the landlord of the vacant property, grants a lease of the vacant property to that single purpose vehicle, so that the single purpose vehicle becomes the tenant, and tenants classically being understood to be entitled to possession and thus owners with rates liability. Upon the grant of the lease, the single purpose vehicle does something which causes it to come within one of the exemptions from the unoccupied rate. One of the things which it does is go into what's called members voluntary liquidation. It effectively liquidates itself. The other thing that it can do is a similar form of dissolution of the company. Now, the effect of the first one is that the rates exemption is triggered until such time as the liquidator disclaims the lease. The effect of the second dissolution type of scheme is that the lease becomes what's called bona vacantia, which means that it vests in the Crown and no one is required to pay any rates until the Crown disclaims the lease. Now, there are a number of features of the leases in this case which were important. Because these companies were SPVs, they had no employees and no assets. And it was significant for the court that there was thus no sense in which the SPVs would be capable of actually occupying the properties that they leased. Similarly, the terms of the leases were such that the landlords could determine the tenancy pretty much whenever they wanted to, which in practice would have been if they found a more commercial tenant for the property. So that in a nutshell is the scheme. It's worth stressing that the court didn't say that the leases were shams, that the court accepted that these leases had vested the entitlement to possession in the property law sense.
In the real property law sense, they've done what it said on the tin.
Absolutely.
In the rating sense, they haven't.
Yes, that's where the court got to.
Yeah, okay. And the result of that scheme was that there was the ratepayers and the landowners had an incentive in delay, because the longer the delay, the longer the rate mitigation advantage would be before the leases were disclaimed.
Absolutely. And of course, in previous cases, that delay, which was deliberate by the liquidators, has been held to be an abuse of the insolvency legislation.
And it's very interesting in the Rossendale case that paragraph 46 of the judgment, which we're not going to read through now, but paragraph 46 of the judgment sets out all of the features of the arrangement that just look quite astonishing. It was a deliberate, I mean, it was a very contrived arrangement from beginning to end, and every element of it was contrived and lacking in any real world substance. The issue there, of course, was who was the owner in the circumstances there. And even though there was a lease under which Hurstwood had her rights of occupation and possession, they were deemed not to be the owner, and even though the term owner is defined in the statute. So what that means effectively is that the Supreme Court has used the purposive approach to construction in quite an extreme way. Normally you see the purposive approach to construction assisting in deciding between two possible interpretations of the words used by Parliament. Here, Luke, what's your take on the approach to purposive construction by the Supreme Court?
Well, my take on this is that this is purposive interpretation in quite an extreme way. In fact, in a very extreme way. As you've already said, Dave, the paragraph 46 sets out a whole load of sort of unreal or uncommercial characteristics of these leases. But the one thing which was held to be genuine was the passage of entitlement to possession. And that, of course, is the one thing that the statute says is required of an owner. Now,
the actual definition of owner is in those terms.
It is in precisely those terms. It's the person entitled to possession. Yeah.
And if you've got a lease, you're entitled to possession as a matter of law. As
a matter of property law, that's right. What the court said was that the Parliament, when it passed the legislation and created that definition, can't rationally have envisaged ownership vesting in a person who was entitled to possession, but who, because of the circumstances, couldn't in a real and practical sense either occupy or give someone else the right of occupation of the property.
And so we have to be quite careful here. The word possession was used by Parliament in defining the owner.
It was.
The Supreme Court said that this form of legal possession, Parliament can't have meant this.
That's right. And I myself find that very troubling. In effect, it seems to me what the Supreme Court has done is altered the test from entitlement to possession to entitlement to occupy. That seems to me, in practical terms, the ramifications of the court's judgment. And that's problematic because, of course, occupation and possession are not the same thing in rating, and they've been treated differently by the courts since at least the Hollywell and Halkin judgment, which was in the late 19th century. Parliament chose possession.
There's some features here that you might say that, I mean, if this wasn't the Supreme Court, you might be saying there's some features of the judgment here that are quite surprising. First of all, the case law, macro, PHE and all that wasn't cited and wasn't referred to in the judgment. It seems to imply that there's a general avoidance rule in the rate system when, of course, Parliament has not applied the general avoidance rule in the rating system, expressly hasn't applied it in the rating system. And effectively, all those cases like macro and PHE, which have paragraphs saying it's not for me, the court, to decide whether or not this is to take advantage of the scheme. It's simply whether there is possession or whether there's occupation in accordance with the parliamentary language. So some features here which are quite surprising. But of course, some people would say that looking at the facts of that case, the purposive approach to construction is perfectly legitimate. I mean, it can't possibly have been Parliament's intent that you can set up a true company having a true occupation, but then commit criminal offences in terms of the way you're setting them up for failure, the way you account for them, and organising the whole scheme in order to give the impression of possession and occupation rather than the reality of it.
Well, I think there are.
Where do you draw the line?
I think there are 2 points that I'd make in response to that, Dave. The first, and as you rightly say, it's a feature identified by the court in this case, is that the directors of these SPVs have probably acted unlawfully in that they've breached their duty not to incur debt for a company when it can't pay those debts, and or potentially committed criminal offences in not telling people about what they were doing in the bona vacantia version. But of course, there's a whole body of case law that says that, you know, if you have a criminal offence or an unlawfulness in one area, you don't necessarily punish that unlawfulness in another branch of the law. You know, one thinks of situations like the Best case about squatters and adverse possession, for instance. One thinks about the PAG case in this context. You know, the Court of Appeal said there was a breach of the insolvency legislation, and the persons responsible should be punished for that breach of the insolvency legislation. But it doesn't follow that you distort the rating system to punish them again. Right. So there's.
Now, we're going to come on to the implications of this judgment in a moment, but there's one way of reading the judgment, which is it's very narrow, that it's a very narrow ratio based on the paragraph 46 factors, which are all quite extreme factors that we don't get in a macro type situation, or in a PHE type situation, or even in a principal situation, I think, where effectively the court was saying, on the precise facts of this precise scheme, it doesn't work for these reasons, and there's been and they've used the purposive approach to construction on the precise facts, and what was, I mean, clearly the Supreme Court thought the whole thing was an abuse. Now, on that narrow reading, of course, the only schemes that will be impacted are the precise schemes the same. But I think you and I agree that this case is going to have potentially much wider ramifications. First of all, it's the Supreme Court. Secondly, it seems to drive a coach and horses through the idea that the courts don't apply a purposive approach to statutory construction in the same way in the rating sphere, which I think is embodied in the last paragraph of the macro judgment, for example. So what do you say? What are the potential implications of this more outside the specific scheme that was in consideration in Rossendale? What are the wider implications?
Well, I think that the wider implications fall into a number of categories. I mean, the first point to note, of course, is that however narrow the Supreme Court's ratio is, and I agree it can be read very narrowly, decisions of the Supreme Court inevitably have ripples throughout a system. You know, one only has to look at what happened after Woolway and Mazard. You know, that in a sense had a narrow ratio, but of course the ripples were so dramatic that it ended up needing legislation to fix the problems. There are, I think, a number of forms of fairly conventional property arrangement which are vulnerable to being revisited in the light of the approach which the court's taken.
So can we go through them? So let's look at the macro type situation, but a sort of extreme macro where the boxes are only there there's no purpose in the boxes being there other than as a rates mitigation scheme. So effectively a principle.
That's a principle type of case, yeah.
And I think in principle it was expressly acknowledged that for the purposes of the litigation at least, it was acknowledged that the only purpose was a rate mitigation scheme.
That's right.
That worked in principle on the basis that the benefit of the boxes being there, the beneficial occupation, was the rates mitigation. And obviously, there's an argument there as to whether that's just a circular argument, that you get your rates mitigation because you're in beneficial occupation, but you need the beneficial occupation to get your rates mitigation. So there's which comes first, chicken or egg. But the implications for that sort of situation for Rossendale, the implications of Rossendale for that situation.
For that sort of situation, applying the Rossendale and Hurstwood logic, one could say that when the legislature, I should say, passed Regulation 5 of the Unoccupied Property Regs, which gives the 6-week occupation reset, as it were, that triggers a fresh 3-month exemption, that the legislature can't rationally have intended that to be applied where the occupation was, as it were, an artificial occupation, or one that was purely for rates avoidance purposes. The same kind of logic can be taken from Rossendale and applied directly to a principled sort of scheme, it seems to me.
Yeah.
And that's particularly so because the whole foundation of principle and of cases like Macro, Sunderland and Sterling, the Wootton case in the Upper Tribunal is the same, culminating in Public Health England. The whole that whole line of authorities rests on a foundation that the court is not concerned with the morality of what's going on.
Yeah.
And that comes from
just gets rid of that principle entirely.
That's right. The Supreme Court applied what's called the Ramsey principle of interpreting tax legislation, which effectively undermines that approach. Yeah. The reason the courts said in Macro and so on that they weren't courts of morals was precisely because the Ramsey approach wasn't applied to rating legislation. Yeah. It's a striking feature of Rossendale and Hurstwood that the court doesn't appear to have had any of the Macro line of cases drawn to its attention. Yeah, so it's done it by accident.
When we were talking about this the other day, we were quite taken by what wasn't argued in front of the
system. Absolutely.
And it's quite interesting that lots of the issues that have been argued repeatedly in the Macro type line of cases just didn't crop up at all, as far as we can tell, in the discussion or the cases that were referred to.
No, that's right. The court seems to have been unaware that it was disturbing a separate line of authority.
We haven't got much more time, so we need to move on. But what's the headline point then for owners of empty property arising from Rossendale, do you think?
I mean, the headline point, in a sense, the headline point is a re-emphasis of the importance of what's always been sound advice anyway, which is that the more commercially realistic your 6-week occupation is, the safer you're going to be. Yeah, I think an occupation where the only conceivable benefit is the rates avoidance is a type of occupation about which questions are going to be asked now. Yeah. I think a true occupation where there's a freestanding separate benefit, as in the PAG case or Macro, is probably going to be safer. But the more real the purpose, the better. The more real the purpose,
even if there's also a subsidiary purpose of rate mitigation.
Absolutely, yeah.
Okay, and then from local authorities, I guess the message is if it looks like an abuse, the more extreme the rate mitigation scheme, the more strong the imperative to look into it and test it.
I think that's right. I think local authorities have largely been applying that sort of approach anyway. But what the Supreme Court's done is it's brought into this field of the law a series of tools which local authorities can use to challenge what might be thought to be well-established schemes up to this point.
Okay, right. At that point, we're running out of time. So if I can bring Jenny and Admas on just to ask if they've got anything they'd like to add or any questions that arise from that. Is Admas available? Jenny, have you got anything?
Hello, everyone. Hi, morning. I think obviously it's really interesting the relationship between the Supreme Court case and the sort of PHE line of cases. But I suppose in terms of how local authorities pursue macro type cases, obviously the by overwhelmingly usual procedure is to go from liability order in the mags. And it seems to me that At that stage, you're not going to be able to bring in the Supreme Court type arguments, because you've got binding authority in the High Court in Public Health England, which is pretty definitive about what the rules are for a macro type scheme. It's even got an appendix setting out the legal principles and the procedures. So I would have thought for a local authority trying to raise that type of argument and bring it in, you'd need to potentially go by a different procedure. I mean, of course, you can do a case stated appeal to the High Court from a magistrates, but then, of course, you've got persuasive authority in the High Court on specifically that scheme. And we know from Kenya Aid that you can't appeal a High Court case stated appeal. So it may be that billing authorities may want to be a bit more imaginative about how to bring that type of point.
Because otherwise we'll end up in a situation where there'll be contrary, inconsistent judgments at all levels of the court system. With the magistrates not knowing which one to...
and if you can't go higher, which you can't after case stated, you can't go to the Court of Appeal, then it's going to be problematic. So
now, of course, the collection and enforcement regs contain an alternative mechanism to the liability order, which is to pursue the unpaid rates as though it were a civil debt.
Just as a debt, and then you could get that all the way up to the Supreme Court.
Then you go all the way to the Court of Appeal and the Supreme Court order.
And that, I think it was North Somerset was pursued that way, wasn't it? The demand notice case. So that,
A question's been raised in the comments about whether the point in principled is likely to get relitigated. I always thought that the judgment in principled was clearly wrong. Luke obviously disagrees with me on that.
Well, Dave and I were on opposite sides of that one, weren't we?
Paragraph 125 of that judgment introduces the circularity I was talking about earlier, but it does strike me that that principled is exactly the sort of next test case, frankly, and how one goes about litigating it or re-raising those sorts of issues is a matter further down the line. But in terms of as I was reading Hurstwood for the first time, I thought, hang on, this is makes principled impossible to sustain. That was my judgment. I think Luke may say that you'd be able to distinguish, but anyway.
I'm not sure I'd go as far as impossible. I think the principle ultimately turned on the meaning of occupation rather than ownership, and there are some differences in the way the courts treat them, but it certainly raises.
Of course, if you're approaching it with a purposive approach, and Parliament's actually defined owner and hasn't defined occupier, then the purposive approach might be even more flexible.
And in some ways, it's even more flexible because the definition of occupation in the statute is what the courts have always said it was.
Exactly.
So you're right.
I think the message we're giving here, Jenny and Admas, if Admas wants to come in, is that this is a minefield for the future. And there's a lot of the established principles that may end up being looked at afresh in the light of the Rossendale judgment.
Absolutely. I think that point about intention to occupy, which is one of the threads through macro and principled and PHE, and that's that intention. The intention coupled with very slight occupation amounts to occupation, and that intention is held to be clearly demonstrated by the fact you've got rates mitigation in mind. And that's how it works. I think that's what gets around your circular argument slightly, Dave. But I agree, that's all common law. It's not definition. It's not statutory definitions. So as you say, it's much easier for the court to manipulate if they can, if they want to get into that morals area, which of course they very much stayed away from in the rating until the Supreme Court case. So
there's just one further question that, and then we'd better move on. And it's about whether or not this purposive approach may subsequently be capable of being applied in a valuation context. Not just in a liability context, but in a valuation context. I think I would ask the author of that question to give a bit more flesh to that in what context you're thinking of. But the purposive approach to statutory construction is embedded, and in fact, for my purposes at least, the rates scheme has always seemed a bit of an aberration in the sense that it hasn't adopted as clear a purposive approach to statutory interpretation as elsewhere.
I mean, one thing that's worth bearing.
If one's looking at things like the units of assessment or paramount control, as the question has come up, then absolutely the same. Once one gets a purposive approach into the rating scheme, then it has potential to have ramifications all over the place, frankly.
And of course, even in the purest valuation type questions, what is the RV of this unit? There's a sense in which a purposive approach was taken by the Supreme Court in Tillary or Trillium. You know, there were conflicting views. You know, you had on the one hand, the statute says what would the market give for it, and it was common ground the market wouldn't have given anything. But the court said, no, that's not what rates is about. It's about finding this fair basis of comparison for tax purposes. Now, of course, none of that's in the statute. That's all purpose and context and background. So
and
I think the percentage already happened. Yeah. But
in Telluride, I don't think they referred to it in the sense of a purposive approach to construction. They didn't call it that, no. But I think in substance, that's what it was. Yeah. Or certainly the majority judgment. The minority judgment took what lawyers would call a more literalist view, I think. I think we brought it to a close there on Rossendale, but people listening might just want to understand that in Rossendale, even the local authority, in its submissions to the Supreme Court, had not made submissions on the purposes of the legislation. The Supreme Court criticised everyone for not going back to first base and understanding the basic premise and the basic purposes of the legislation, and said, well, how do you decide how to apply the legislation if you don't know what the purpose of the legislation is? And so that's quite a stark warning for all of us, I think, for the future. Anyway, I'm going to now ask Admas and Jenny to move on to the discussion, the second part of the agenda, which is the charitable reliefs and the implications of the Nuffield judgment.
Thanks, Dave. Hello, everyone. We're talking about another sort of, well, to some extent, this charities relief is obviously used as rates mitigation as well. And I'm going to be talking a little bit about a case from last year, a High Court case from last year called Preservation and Promotion of the Arts. And then I'll ask Luke to talk about Nuffield, and then we'll have a brief discussion about how the two cases interact. Preservation and Promotion of the Arts against Bolton and others, a decision of the High Court of last year, as I said. It was a judicial review and case dated appeal against two magistrate courts' decisions, one in Bolton and one in Birmingham, whereby liability orders were granted to billing authorities for unpaid rates. And the ratepayer, Preservation of the Arts charity, unsuccessfully argued that it was entitled to charitable rates relief. It was not a registered charity, but by the time of the High Court hearing, it was accepted by all parties that it was a charity, albeit not registered. It was a private limited company with objects including promotion and appreciation of the arts in any form. The case covers lots of interesting procedural issues as to the interrelationship between judicial review and case dated appeals, and when a case dated appeal can be valid, and when the fee must be paid, all those sorts of things, which we don't have time to touch on. But the substance of the case is really interesting because it involved a fairly well-known rates mitigation type situation where charity was occupying the property on beneficial lease terms and was using it for what it said was art exhibitions held on some days and then empty periods in between. And those art exhibitions were said to be in pursuance of its charitable purposes. And it was claiming relief on two bases. One, that on the days when it was used for the art exhibitions, it was claiming relief under section 43.6, so on the basis that the hereditament was wholly or mainly used for charitable purposes on those days, and so entitled to 80% charitable relief for occupied rates. And then on the unoccupied days, it was claiming zero rating on the basis that, quote, it appears that when next in use, the hereditament will be wholly or mainly used for charitable purposes, and that's under section 45 capital A. And as I said, the background to this was that the High Court recognised that it's well known that arrangements are made by landlords to lease property to charities at favourable rents, so that the charity then becomes liable in place of the landlord, and then the charity is also able to gain reliefs under those mandatory relief provisions. And the court recognised, again, touching on this point that was raised in the earlier part of the talk, that this is a court of law, not a court of morals. So the court's aversion to such tax avoidance scheme should not in any sense be a relevant factor in the determination of whether the charity is entitled to the relief. So the issue in the case was whether the district judges had been in error in determining that the hereditaments were not wholly or mainly used for charitable purposes. And as part of that determination in the High Court, there was quite a lot of emphasis on the definition of charitable purposes under the Charities Act 2011, and particularly sections 2 to 4 of the Act. And those provide that for a charitable purpose to be a charitable purpose, it has to be both listed as one of the purposes in the Act. It has to be a purpose within one of those listed purposes in the Act, and crucially, it must also be for the public benefit. And the statute, the Charities Act, specifically states that just because you're listed as one of those purposes in the Act does not automatically mean that it's assumed that the purpose is for the benefit, for the public benefit. That has to be shown separately. And public benefit test includes 2 limbs: one, that it must be of benefit to the public, but also that it must be available to a sufficiently wide section of the public. And the High Court in Preservation of the Arts really focused in on that and considered that it was a matter of evidence as to whether these activities that were carried out at the hereditament were for the public benefit. And particularly whether the quality of the art on show was sufficiently high to be for the public benefit and to be capable of being in pursuance of the charitable purposes. And it was also decided that the burden of proof was on the charity seeking that relief to show that this was for the public benefit, and if necessary to produce expert evidence to that effect. And given that it hadn't done so, the High Court held that the district judge had been entitled to conclude that the art on show was not of sufficient quality to be for the public benefit, and so the use was not for the charitable purposes, and that was in the Bolton case, and the liability orders were granted on that basis. In relation to the Birmingham case, some different points were raised as to the sparseness, as it was called, of the use of the property, the absence of attendees to the exhibitions, the absence of any significant advertising, and the access arrangements for the public being pretty minimal. The court held that the district judge in those circumstances was entitled to hold that there was no persuasive evidence at all that the charity was pursuing its charitable purposes in any real sense. And so whilst the objects were ostensibly charitable in its article of association, it wasn't actually pursuing those in its use of the property, and so was not entitled to the relief. It's a really interesting case. It really did focus in on what, the court was really quite active in focusing in on what the public benefit was, what the charity was doing, scrutinising the charity's activities in a way that perhaps is something one might think more for the Charities Commission rather than for the Rates Authority and potentially for the Magistrates Court. So I'll come back to that when we have a discussion, but I'm now going to hand over to Admas for another case on charitable relief, slightly different, but which certainly interacts with some of the issues raised in preservation of the arts. So Admas.
Thank you, Jenny. I'm going to summarise the Court of Appeal's decision in Nuffield Health and London Borough of Merton, and judgment was handed down on the 28th of May 2021. That appeal was concerned with the question of whether a gym in Merton in South London that was operated by Nuffield Health whether Nuffield Health was entitled to an exemption on the basis, to mandatory rates relief under 43(6)(a). There are 2 requirements under that provision. The ratepayer has to be a charity or trustees of a charity, and the hereditament has to be wholly or mainly used for charitable purposes. Nuffield Health was a company limited by guarantee and a registered with the Charity Commission. It described its objects as to advance, promote and maintain health and healthcare of all descriptions, and to prevent, relieve and cure sickness and ill health of any kind for the public benefit. At first instance, so before it came to appeal, the judge found that Nuffield Health were entitled to rates relief because A, they were a charity, and B, the hereditament was indeed wholly or mainly used for charitable purposes. It's only the second of those issues that the appeal court was concerned with. The judge's reasoning had been that Nuffield Health, as Jenny mentioned, the charitable purpose criterion has a public benefit aspect to it, and the judge had held that Nuffield Health was not required to show that the premises itself was being used by the public benefit. They could show that the premises were being wholly or mainly used for charitable purposes without having to actually show that for the premises specifically. Merton appealed against that judgment. They appealed on a number of grounds, but I'm only going to focus on the two that are relevant for our discussion today, which were the focus of the judgment. The first ground was that the judge was wrong, and Nuffield Health are required to show that the premises itself was being used for the public benefit. It's not enough to say that their activities generally were for the public benefit. You had to show that this gym in South London was also being used for the public benefit. And then following on from that, they said that in fact, the gym was not being used for the public benefit. So that was their ground 3 out of the 4 grounds, and that only arose if they were successful on the first ground 1. The majority disagreed with Merton on ground 1, so the majority upheld the trial judge, the first instance judge's conclusion that in terms of public benefit, the focus is on the purpose of the charity itself, not the use of the specific hereditament. They noted that in order to benefit from the relief, you have to be a charity in the first place, and the focus, the wording of the provision suggested an attention on the overall purpose of the charity's activity. Now, the provision talks about wholly or mainly for charitable purposes, but the court made the point that this goes to the level of charitable use, not to whether the nature of the use is charitable. And essentially much of the case law went to that issue and not to the issue the court had to decide. There was very little case law actually specifically on this point about whether you had to look at public benefit at the level of the hereditament. So the court, essentially, the majority was looking at the wording of the statute and taking a view on what the better interpretation was. And the factors that they ended up relying on were the predecessor legislation. So the going back to the 1955 Act, that made it clear that the question is whether the objects of the organisation were charitable, and the court said, well, we don't consider that the legislation has changed since then. There's also reference to a parliamentary report which led to 43.6 or to its predecessor, and the court took the view that that pointed to a broad brush approach and it suggested that the eligibility dispute was at the level of the charitable status of the organisation, not the hereditament. The court also placed some focus on the role of the Charity Commission, and it took the view that it's the Charity Commission and not individual billing authorities that should be the arbiter of whether a charity is performing its responsibilities. And so it said, given that Nuffield Health has to convince the Charity Commission that it's been established for charitable purposes only, it would be odd if that conclusion could be subverted in relation to individual premises. It also highlighted some of the practical issues that could arise if Merton's argument was successful. So it could lead to anomalies with, for example, in Nuffield Health's case, different gyms in different areas having different statuses for the question of rates relief. It would require billing authorities to conduct very detailed evaluations, looking at, for example, in this case, extent of the services provided, demographic evidence, and so forth. And essentially, the court said the public benefit should only be assessed once by the Charity Commission. So on the main argument, the council lost, and the decision was upheld. It's worth noting that on ground 3, which only arose if Merton had been successful, that is to say, was the hereditament being used for the public benefit, the majority actually found that they would have concluded that it was not being used for the public benefit. There was a dissenting judgment, but the majority said that given that Nuffield Health was essentially providing a commercial service, that you wouldn't be able to conclude that that was for the public benefit. But on the majority's view, those issues are really to be dealt with at the Charity Commission level and not at the billing authority level. So
Great.
that's my summary, and we can discuss a bit more now.
Thanks, Admas. Yeah, I mean, I think it's really interesting that preservation of the arts wasn't referred to by the Court of Appeal in Nuffield. And I think there is a bit of a tension between the two decisions because, as I just said, in preservation of the arts, the court plainly considered that to be eligible for charitable rates relief under section 43(6), part of demonstrating that the hereditament was being used for charitable purposes entailed demonstrating that the use was for the public benefit. Whereas, of course, as you say, in Nuffield Health, the majority in the Court of Appeal decided that it could be conclusively assumed that the charity's purposes were for the public benefit because they're a registered charity, and therefore it was only necessary for the billing authority to consider whether the occupier is a charity using the premises for its stated purposes, and no need to consider at all whether the activities at the hereditament were for the public benefit. So there does seem to be quite a tension between the two decisions. And I just wondered, to what extent do you think perhaps, if at all, that contradiction could be explained by the fact that preservation of the arts, the charity was not a registered charity, whereas in Nuffield Health, obviously it was. Do you think that can explain the difference?
I mean, that issue is potentially relevant in two respects. First is the question of whether or not the entity is a charity, and then secondly, in terms of the analysis of whether or not the hereditament is being used for charitable purposes. So in the preservation and promotion of the arts case, as I recall, it was accepted that they were a charity, so then that issue doesn't arise there. In terms of the approach to charitable purpose, there is a clear divergence between the two cases, and applying the Court of Appeal's approach, you would not need to make that out. There would be no need for an inquiry. The lack of registration point is an interesting one because the Court of Appeal leans heavily on the role of the Charity Commission. They identify it as a separate practical consideration. We don't want to have multiple assessments by billing authority and so forth, but it also feeds into the way they analyse the wording, actually, the interpretation of the wording. And that is absent in a case where a entity has not been registered. But it's also part of the Charities Act framework that so in the preservation and promotion of the arts case, the ratepayer said, well, we're too small to be registered, and that's correct. There's no requirement to be registered with the Charity Commission if your turnover is over a specific sum, 5,000 or something a year. And so there is, their point was no inference could be drawn from that, which seems like a fair point. I think there is scope for argument that could lead to a different analysis. It's just something that's not explored essentially by the Court of Appeal because it didn't arrive.
Yeah, I mean, I think it's always been a bugbear of mine, to be honest, that that all these issues about public benefit and about regulating charities really fall outside the sort of expertise and the scope of a rating authority or the Magistrates Court in these circumstances. So I'm quite pleased to see that coming out of Nuffield. But it is, in terms of the registration point, though, to be a charity, and it was accepted, it was a charity in preservation of the arts. Once you accept that, you accept the definition, and the definition in the Rating Act is the same as the definition in the Charities Act, i.e. an institution or other organisation established for charitable purposes only. So arguably, you know, once you've agreed it's a charity, you can read across that statutory definition from Nuffield to future preservation of the arts types cases. So but I agree that the role of the Charities Commission does seem quite crucial. And if that's not present, I can see a court being less keen to follow the Nuffield type line on that.
Well, I mean, a future preservation and promotion of the arts type organisation could say, well, none of those features are present in our case. Or excuse me, the billing authority would likely say they're not present in our case. So we have to the court has to answer them. The billing authority has to answer them first, and the court should also look into them.
But arguably, you've already answered them if you've agreed it's a charity. So you know, it's interesting. What about the background to the kind of rates mitigation type scheme, which obviously seemed to be present in preservation of the arts, but not in Nuffield? To what extent do you think that affects the outcome?
Well, the judge made it pretty clear that that's not a relevant factor. If if the courts are going to be considering public benefit, it would seem to be relevant in that evaluation.
Yeah, yeah. Okay. Well, I think we probably need to bring Dave and Luke back in now. But one thing I just wanted to finish on, perhaps we can all come in on this, is to what extent do we think if a preservation of the arts type case were considered post Nuffield, and just assume for the moment that the preservation of arts type charity was a registered charity, do we think the outcome would be different now we've got Nuffield? I've got my own views, but perhaps we could, anyone else got any views on that? I mean, for what it's worth, I think that the interrogation as to the quality of the art, you could argue quite clearly that that sort of public benefit type interrogation is not a place for the rating authorities. That's for the Charities Commission.
And indeed, as has been said, the Charities Act proceeds on that basis. That's why it has the conclusive presumption. Yeah, it is to safeguard questions like that to the body which has the legal and institutional expertise to answer them, which is the Charity Commission, and not a local magistrates court. So in that sense, it seems to me that the Nuffield approach is more consistent with general principle and with the Charities Act. And I suspect myself that it would lead to a case like preservation of the arts going the other way, at least potentially.
I think certainly in terms of the quality of the art point, in terms of other points like whether the exhibition was advertised or whether it was open to the public properly, whether it actually happened, whether the building was used fully, or those sorts of issues, I think are legitimate for the rating authority, because they're things like whether it's wholly or mainly used and whether the purposes are being pursued at all, whether there is actually promotion of the arts happening.
As opposed to rates avoidance, which in a sense it pulls in. It pulls in quite neatly what Dave and I spoke about in the first half. Which is if you have a rates avoidance use, which is alongside an arts charitable type use, which is the main one. Now that's not a question for the Charity Commission. That's clearly a question for the authority and then the courts on appeal.
But not bringing in the public benefit test though, because the public benefit test is assumed even in a circumstance where you've got potential rates.
That's right. What you can't do is say that the art exhibition, if it happens, isn't for the public benefit. What you can say is that something else was happening as well, and that was the overarching purpose. Because otherwise you end up in a position where you say everything that the charity is doing is necessarily for the public benefit, and that can't be right, because Oxfam tells us that it's not.
Or you could go so far as to say it's not, even though there's art on display, it's not really an art exhibition, and that would bring in Jenny's would conflict with Jenny's approach. But it would argue, I mean, that's never been decided whether that's open for up for grabs in this sort of situation. So whilst Admas was talking, the Oxfam case came to mind. As to whether or not what was being talked about in Nuffield was in fact a commercial way of supporting the charity objectives, and in fact a question has been raised on that same question. Commercial premises with revenue being used for why is that in practice any different from a charity shop as in Oxfam?
That was one of the grounds of appeal, but that was dismissed at first instance because the evidence wasn't before the court to come to that conclusion, and the appeal dismissed likewise.
Okay, but on a particular set of facts, you might be able to run an Oxfam type analysis.
It was, the fundraising was definitely raised in that, wasn't it, Admas? And as you say, it was, they just they didn't have enough evidence to show that there was a surplus being generated in that sense and being used for other purposes. So,
Good. Okay. Well, I think that brings us to the end of we're slightly over running our time. Unless there's any last minute questions coming up on the question and answers, I don't think there are. So that then just leaves it for me to thank the speakers for their time and for their contributions, and also to thank the very large number of people who've listened in. I hope you found it useful. I think the link to this seminar will be on our webpage and will be sent around to you all shortly. So thank you very much. Have a good day. Thank you.
Thank you.
Thanks very much. Bye-bye.
Bye all.